session of the third International Conference on Mediation, organized by Faculty of Law, University of Delhi, and Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi, in association with Mediation and Conciliation Project Committee, Supreme Court of India. The topic of the session is Cross-Border Dispute and International Mediation in International Perspective. To discuss various aspects of it, we have a stellar list of distinguished speakers, with each of them being an expert in their own domains. I humbly invite Honorable Mr. Justice Ajay Bhenot, Judge, Allahabad High Court, as our esteemed chair, His Excellency Dr. Cameline P. Ponodol, Secretary General, Asian African Legal Consultative Organization, New Delhi, being the respected co-chair, and our guest of honor, Dr. Aniruddha Rajput, member, United Nations International Law Commission, and an admirable special guest, Shri A.J. Jawad, Mediator, Partner, and Head of ADR Services, KD Lex Chambers. Professor Dr. V.K. Ahuja, Hon'ble Vice-Chancellor, NLUJA Assam, and Joint Director, Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi. Before we proceed with the session, I request to all the participants to fill the feedback form available in the chat box. Kindly note that filling the feedback form is a mandatory requirement for certificates. Without any further ado, let me invite Professor Dr. V.K. Ahuja. Sir is the Vice-Chancellor of National Law University and Judicial Academy, Assam, and Joint Director at Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi. An academician par excellence, Professor Dr. V.K. Ahuja earned his Masters in Law from University of Delhi and Masters of Philosophy from Jawaharlal Nehru University. Having completed his PhD from University of Delhi, he has published over 50 articles in acclaimed national and international journals and scores of book chapters in the field of intellectual property laws and international law. Sir, the virtual floor is yours.
Thank you, Dr. Dhananjay. Honorable Mr. Justice Ajay Bhenot, Judge, Allahabad High Court, His Excellency Dr. Cameline P. Ponodol, Secretary General of Asian African Legal Consultative Organization, His Excellency Dr. Aniruddha Rajput, Member, United Nations International Law Commission, Shri A.J. Jawad, Mediator, Partner and Head of ADR Services, KD Lex Chambers, and dear participants, a very good afternoon. The theme for discussion is cross-border dispute and international mediation in present international perspective. Well, friends, mediation has proved to be an effective, less time-consuming, friendly, and convenient mode to resolve all types of disputes, be it political dispute, boundary dispute, or commercial dispute, or dispute of any other nature which takes place between the two nations. In India, we see examples of mediation by Lord Rama when he mediated between Sugriv and Bali, mediation by Angada when he mediated between Rama and Ravana, mediation by Lord Krishna who is known as the Lord of Universe, between Kaurava and Pandava. And these examples can be found in our epics, Ramayana and Mahabharata. These mediation happened several centuries back. So the credibility of mediation as a mode of dispute, of resolving dispute is very well settled. All major wars between two nations and with some sort of mediation. And if you just look at the UN Charter, you'll find a reference to mediation in the UN Charter as well as in the United Nations Convention on Law of the Sea, apart from other international instruments. For commercial disputes, we recently have the Singapore Convention on Mediation. To have a discussion on the theme, we have esteemed panelists for the session on behalf of Faculty of Law, University of Delhi, Delhi School of Public Policy and Governance, University of Delhi, and MCPC, Supreme Court of India. I welcome the chair of the session, Honorable Mr. Justice Ajay Bhenot, Judge, Allahabad High Court. I also welcome co-chair of the session, His Excellency Dr. Cameline P. Ponodol, Secretary General of ALCO, who had recently joined ALCO, which is based in Delhi. I also welcome my friend and guest of honor, His Excellency Dr. Aniruddha Rajput, member of the UN International Law Commission. Finally, I welcome our special guest, Shri A.J. Jawad, mediator, partner and head of ADR services, KD Lex Chambers, who has always been very kind to us and participate in all our programs whenever we approach him. With these words, I welcome you all. Over to you, Dhananjay.
Thank you so much, sir, for taking out your time and joining us today. I would now like to request Shri AJ Jawad to address the virtual gathering. Sir has been a mediator since 2007 and a passionate promoter of mediation in India from its earliest days. He works as a mediator and trainer with the Mediation and Conciliation Project Committee of the Supreme Court of India and as a global faculty with ADR ODR International, UK. He's a semi-accredited mediator and has recently joined KD Lex Chamber as a partner and head of ADR services. Sir, the virtual floor is yours.
Sorry, I was muted. Thank you, Dr. Dhananjay, Dr. Professor Ahuja. Honorable Chair, Mr. Justice Ajay Behnot, Judge Allahabad High Court, esteemed co-chair, His Excellency, Dr. Kamalin, guest of honor, Dr. Aniruddha Rajput, the moderator of this section, Dr. VK Ahuja, the prime mover and shaker of this conference, my dear friend, Dr. Ashutosh Mishra, and friends, colleagues, and students who are attending the session today. I'm thankful to the Faculty of Law, Delhi School of Public Policy and Governance, Institution of Eminence, and the Honorable Mediation and Conciliation Project Committee, Supreme Court of India, for giving me this opportunity to speak at this August gathering. Being the first speaker and having more eminent speakers coming in after me, I want to utilize the time provided to me to discuss cross-border mediation from the international perspective without going into the Indian context. I'm sure that my esteemed co-panelists will take us deeper into the subject. Well, as we all know today, information technology, social media, and artificial intelligence have changed the way we live and do business. Territorial borders have lost meaning. The industrial trade and consumer markets have become global, targeting new markets across borders and consumers exploring new products and services that are exclusive, affordable, or unique. I think multinational companies have never had it so good before as they have now. Now, one of the results of this trend is that commercial disputes have taken on new dimensions, which include foreign counterparties and multinational entities. While researching for this session, I came across a very interesting paper by Thomas Gaultier. I hope I have pronounced the name correctly, which is titled Cross-Border Mediation, a New Solution for International Commercial Dispute Settlement. Gaultier points out, I'm quoting, in dealing with the evolution of commercial conflicts, parties have increasingly found the national court systems inadequate for various reasons, ranging from cost, delay, inability to handle the technicalities of international disputes, and lack of qualification of national judges. Therefore, the actors of the global commercial scene have turned to alternative means to solve their disputes. Quotation closed. Now, for a considerable length of time, arbitration ruled the roost as it offered some advantages such as confidentiality, flexibility, choice of venue, choice of forum that were lacking in litigation. However, arbitration also has some serious drawbacks, increasing costs, delays, lack of finality, and so on. Now, some international commercial entities have been recently turning to another process of alternative dispute resolution, namely mediation. Now, the evolution of the global market and the demand for an even quicker, less expensive, and less adversarial dispute resolution process is leading to a new use of mediation, which was hitherto being used for domestic dispute resolution, namely in connection with cross-border commercial disputes. Now, recognizing the benefits of mediation and cross-border disputes, the European Union adopted Directive 2008/52/EC on the 21st of May 2008. Now, the directive focuses on 5 aspects of mediation. 1, the quality of mediations. 2, court encouragement of mediation. 3, enforceability of mediation agreements. 4, confidentiality of mediations. And 5, the effect of mediation upon limitation periods. that is the time limit within which legal proceedings must be commenced. The directive seeks to address these issues and disputes between parties based in member states, cross-border disputes. The definition of a cross-border dispute is, subject to some exceptions, a dispute where at least one party is domiciled in a member state. Now, member states were required to bring into force laws necessary to comply with the directive by 21st May 2011. What is interesting is there is also the Online Dispute Resolution, ODR regulation, which led to the establishment of an online platform, a free website, which is available in all the languages of the EU, by which traders and consumers in member states can attempt to settle disputes relating to online sales or service contracts. All traders within the EU, which engage in online sales, service contracts, and online marketplaces, are required to provide a link on their website to this ODR platform. Now, in the paper that I referred before, Thomas Gaultier points out that in order to evaluate the effectiveness of mediation for cross-border disputes, there are three elements that should be taken into consideration. One, the enforceability of the mediation clauses, that is the agreement to mediate. Some of these clauses may be incorporated in the original contract itself, perhaps preceding an arbitration clause. The second aspect is the enforceability of the mediated settlement agreements. So what is the status of a mediated settlement agreement? What happens if you reach a settlement through the mediation process? And finally, the success rate of the settlement procedure. How far is it successful? Now, in most international commercial contracts, the parties include a dispute resolution clause, which in many cases is only an arbitration clause. Now, there is often a clause that requires the parties to try to resolve any dispute in good faith before they invoke the arbitration clause. Parties usually construe this to mean that there should be a negotiation preceding the arbitration. Now, invariably, such negotiation, being an unregulated one, is never undertaken, or even if it is, it fails. Now, on the contrary, a mediation clause is increasingly being regulated, and in some countries, courts refuse to hear a claim if mediation was not attempted beforehand. Now, in countries such as Germany, England, Belgium, and France, the legislature or the courts have already provided that in cases where the mediation clause is sufficiently clear, the courts will not hear a claim if one of the parties has invoked the duty to mediate and that duty has not been satisfied. Now, even though the European directive is silent on the issue of the enforcement of mediation clauses, it appears that an increasing number of states are already adopting some form of regulation in order for mediation clauses to be enforced. Now, this enforceability contributes greatly to the development success of mediation in cross-border disputes, since the parties are now assured that they can benefit from trying to mediate the dispute before moving on to an adjudicated procedure. The second important element relating to the effectiveness of cross-border mediation is whether the mediated settlement agreement can be enforced by state courts. Now, it is in this context that the United Nations Convention on International Settlement Agreements resulting from mediation, which is otherwise called the Singapore Convention, has become the game changer. Now, before this, there were two different ways that courts could possibly enforce mediation agreements. First, by simply ratifying the settlement agreement and issuing a court order for its enforcement, or second, recording the settlement agreement in the form of an arbitral award. Even the Indian Arbitration and Conciliation Act of 1996 has something similar to that. Now, otherwise, the mediated settlement agreement would be nothing but an enforceable contract between the parties, setting out the respective parties' obligations and writing. Now, what happens if there's any breach of terms of such contract? At best, it can lead to parties, again, going back to adversarial proceedings to enforce it. Now, the parties to an international commercial mediation will surely not want to take the chances in mediation if there is the risk that the other party then defaults in its obligations, forcing the non-defaulting party to bring a lawsuit for breach of contract. Now, the convention marks a key point in international mediation as it offers a new legal framework for cross-border disputes. The convention does not change the way that mediations are conducted, but rather makes the mediated settlement agreements enforceable in the courts of the member state. The courts of a contracting party will either enforce an international settlement agreement within the scope of the convention or allow a party to invoke the settlement agreement in order to prove that the matter has already been resolved in accordance with the rules of procedure under the conditions that are laid down in the convention. It could also be possible for the courts to refuse to grant relief on specified grounds laid down in the convention. Now, hopefully, this will give greater confidence to businesses to resolve international trade disputes through mediation rather than through formal processes such as litigation or arbitration. Now, the third aspect that is important is the success rate. Now, studies have shown that in commercial mediation, particularly, the probability of settlement is usually in excess of 80%. The success rate is not just in the US and UK, where mediation is fairly well established, but also in other European countries. A majority of the companies who were surveyed, nearly 87% have also expressed satisfaction with the mediation process. Now, let me conclude by saying that the prospects look bright and express the hope that in India, too, we can see the early enactment of the Mediation Act and the ratification of the Singapore Convention, and also the establishment of a robust mediation ecosystem, both on the domestic as well as the international front. Thank you for the opportunity once again. I hope I have not exceeded my time. Apologies if I have. Thank you so much.
Thank you so much, sir, for your valuable insights and highlighting the role of mediation in cross-border disputes. Now, I would like to request Dr. Aniruddha Rajput to address the virtual gathering. Sir is a member of the UN International Law Commission. His areas of expertise are general international law, dispute resolution, boundary disputes, law of the sea, international investment law, and international trade law. He has taught courses in international law at several universities and presently serves as the member of the Board of the Studies of South Asian University created by SAARC countries. Sir, the virtual floor is yours.
Thank you very much. I must begin by thanking you for the introduction and Professor Ahuja for this invitation. He's my, I must say, very warm academic friend who keeps my academic interests alive and strengthened. It's, of course, a great honor to be a part on this panel being chaired by Justice Bhanot. I've never had the opportunity of knowing him in person or even appearing before him, but it's at least a pleasure to know him virtually, so I'm very pleased. And of course, I'm extremely delighted for the first time to meet in a virtual format the newly elected Secretary General of ALCO, His Excellency Dr. Vinit Puvado. I take this opportunity to congratulate him on his very worthy election, although I've written an email, but a personal warm greeting is more important than an email, and do hope to see him in person very soon. Of course, it's a pleasure to listen to Mr. Jawad, who's an eminent practitioner in the field and has set out what really are the implications and why this is an important exercise. Although the time limit is of 7 minutes, I'll try my best to stick to it and might go 30-40 seconds here and there, and I hope that should not be too much of a problem. The focus that I wish to keep of my presentation on is on investor-state mediation. It is quite a specialized category of mediation which is yet to take off really, and we doubt if it will take off because of the complications involved. And I want to address some of those complications and how far these issues could be addressed. Now, the Singapore Convention is of course a very important and a helpful step on the part of the international community to recognize the importance of mediation. I've had the immense privilege of sending my personal comments to the law minister about what I think about the bill which he wants to present in the parliament. I'm not sure if it is presented yet. But one of my concerns has been it's very nice on the text, but we need to have the culture, which the US, EU, and I wouldn't be shocked to see a good rate in European Union, because we traditionally think of the West as US and UK, but there is a much bigger world which is far more effective within the EU structure, and which there's a lot more to learn, although they follow different legal systems. But I don't want to get there. I really want to keep my focus simply on investor-state arbitration. That is a situation where there is a dispute between a foreign investor and a state, that is a country, not like the state of Kerala or the state of Madhya Pradesh, but it means the Republic of India. By state, I mean in international law, a country as such. Now, the moment a country is involved, there are several complications that arise in a mediation process. Now, let us understand what is happening at the international scenario. The International Center for Settlement of Investment Disputes has set out its own rules on mediation. The International Bar Association has set out its own rule of mediation in investor-state arbitration. The ICC, International Chamber of Commerce, has set out its own rules. LCI has also proposed some rules, although not geared specifically towards investment arbitration. I stand subject to correction. We do see a lot of these institutional rules being made. We also have the example of the EU-Vietnam bilateral investment treaty, which has a reference to mediation. In fact, the most comprehensive discussion on what the procedure should be, what the code of conduct should be in mediation, can be found in CETA, the Canada-EU Free Trade Agreement, which is considered to be the most latest and the most advanced form of free trade agreements that we have, the most latest generation investment treaty, the Canada-EU Free Trade Agreement. The Canada-EU Free Trade Agreement has extensive references. In fact, it sets out the procedure. It even has a code of conduct for mediators. But there it tries to simply borrow from what is happening within the domestic legal system. And that's a bit of a problem, because the concerns in a domestic legal system don't essentially function well when it comes to public international law, and essentially in the context of investment arbitration, so there is an investor on one side and there is a host state on the other. China, in its model bilateral investment treaty, has a provision to that effect. I was a part of the Law Commission of India, which revised the Indian model BIT, and to be honest, I don't remember if we had a provision on mediation, because at that stage this hadn't picked up, but my impression is probably we don't. Now, assuming that mediation is going to pick up or is expected to pick up, do we have the environment conducive in investment arbitration to allow mediation to pick up? Mediation fundamentally is based on confidence between the parties. The commercial parties both have to have confidence with each other that they can sit together and resolve this, of course with the help of a third party. Because as we know, the Singapore Convention quite aptly defines mediation as a facilitated dispute resolution with the involvement of the third party, where the third party really functions as a catalyst. Because if the third party starts acting anything further, anything beyond than simply facilitating the process, then there is a possibility that it might become conciliation proceedings. And I find it a little bit strange, because in investment arbitration there is a big push for mediation, but conciliation has absolutely failed. ICSID has had conciliation rule, nobody has used them. Interestingly, under the UNCLAUS, the United Nations Convention on the Law of the Sea, if a state has made an exception to its dispute resolution clause, then there is something called compulsory conciliation, which is quite a novel concept. And we have the first example of a successful conciliation between Timor-Leste and Australia, where the maritime dispute between Timor-Leste and Australia was resolved by the conciliator. And I had the opportunity of speaking to some of those who were involved in the proceeding as counsel. And what we do see that there is a much active involvement on the part of a conciliator than in mediation. In fact, Professor Thomas Weil wrote a very interesting article about his experience of resolving a dispute between two corporations, a very large energy dispute. I don't remember the name of the article, but if you Google it, I'm sure it will throw up some suggestions. And what we do see is confidence is critical for commercial entities to speak to each other. It's not just the confidence with each other, between each other, but it is also the confidence with the mediator, who is going to have a critical role in ensuring that he is a catalyst to find a resolution. Now let us use these elements and apply them in investment arbitration and see what happens. In investment arbitration, it is often an investor on one side who is suing a state. So there's already a certain degree of discomfort on the part of a state that there's a private investor who is suing a whole sovereign state. And a state is expected to compensate the investor from its taxes, from its sovereign wealth, which it has collected from its taxes. In fact, there have been some examples where the compensation was so high, I forget the name of the state, but there was a Latin American state. The compensation was equal to the health budget for 1 year of that state. So would a state be willing to get into mediation of such kind? There are doubts. In fact, I was speaking on this very topic at the last in-person ALCO conference, which happened in Dar es Salaam, where by when the COVID there was no outbreak and we were still in happier times. And one of the government lawyers, I won't name, but of course one of the ALCO government lawyers came up to me and said, well, but what about confidentiality and how much do we disclose? Because a state may not want to put all its cards on the table, and so also the foreign investor would not want to put all its cards on the table. For mediation to be successful, it is critical that both the parties are willing to put their cards on the table to discuss at least with the mediator how he wants to proceed. If the states are afraid, if the investor is afraid that it might affect my legal arguments, of course the position of the law is it would not, but there's always a fear that my position might be compromised, then there is a problem. What is being sold as the greatest attractive feature of mediation, that is confidentiality, is one of the greatest obstacles when it comes to investment arbitration, because often these investment arbitration involve matters of environment, labor standards. In fact, one of the recent most controversial award of Eco Oro versus Colombia involved a very large forest, and that forest was covered by the Convention on Biological Diversity. The Constitution of Colombia protected it, yet the majority found that the measures taken by the state were contrary. And of course, the dissenting arbitrator wrote a very interesting and a very strong dissent. In this context, where there are issues of public interest involved, can a mediator simply say, well, arrive at a compromise and this is a good compromise? In fact, now there's a practice of having amici brief, amicus curiae presentations made by non-parties, and often these are taken into account by investment tribunals. There are several instances of this. So what is going to happen to that? How is that factor going to be adjusted into all this? So it's quite doubtful, looking at the various segments of investment arbitration or various pieces of the machine pulling in different directions. It's really doubtful if it can create that optimum environment for mediation to proceed further. But if at all mediation ought to proceed, it ought to proceed or based on the credibility of the mediator. These are highly contentious political disputes. Often investors have lost their investments. They are really interested in getting a compensation. That might be a factor to attract them for going forward for mediation, but that might also be a factor to distract them from going for mediation, because they may want to extract as much compensation as they can from an actual investment arbitration proceeding rather than going for mediation. Assuming they do decide to go for mediation, what are the factors on which they are going to agree to it? And there are several factors on states. There are several ministries involved. Are all ministries going to sign off such a settlement? So there's an issue of that. And speaking lastly on the credibility of the arbitrators, because I've already exceeded my time and towards the end of it. So it's a mediator in investment arbitration ought to be someone who's politically suave. He needs to understand the political implications of these disputes. What are going to be the implications for the state, and what are going to be the implications for the investor? It is only if these factors are taken into account there's possibility of creating a balance. I'm not saying that that it would not succeed at all, but it may not be as successful as one might assume it to be, or at least what ICSID thinks it or some of the other international institutions think it is going to be. And some of these principles, not exactly in the same context, are also relevant for domestic law, the domestic context. And there's going to be a real challenge about how the law is implemented and how well we have created the environment for mediation to foster. And I'm very confident that with the contribution of the eminent judges we have, one, we have chairing our panel, Justice Banot, but I'm sure there are many others who have participated throughout this conference. Their incentives and their carrot and stick policy of forcing at times to parties within their limits could also potentially pave way for successful mediation in India, especially for cross-border. And thanks for inviting me. Thank you very much.
Thank you so much, sir, for your valuable opinions and discussing the obstacles to mediation in investment disputes. Now, I would like to make a humble request to His Excellency, Dr. Cameline Pinit Puvadol, to address the virtual gathering. Sir started his career as a lecturer and researched in the areas of private international law, international investment law, international trade law, international economic law, international law on children's rights, and European Union law. He is currently serving as the Secretary General at Asian African Legal Consultative Organization, New Delhi. Sir, the virtual stage is yours.
So thank you very much, It is my great pleasure and honor to be part of this important panel on issue of cross-border settlements. And I'm so happy to be here, and I'd like to salute the Honorable Mr. Justice Ajay Bano, Excellency Dr. Aniruddha Rajput, and Professor V.K. Ahuja, including also Excellency Jawad. And allow me to highlight a little bit about the ALCO, which I'm the Secretary General, as some of you may know about ALCO. ALCO in the past, we have worked on issue peaceful settlements. Is also related to the issue of mediation. And as you may know that ALCO is the outcome of the Bandung Conference in 1955. And 1 year later, ALCO is set up. And the objective of ALCO is mainly on the progressive developments and codification of international law. This is our main task. And also ALCO try to give the perspective of Asian African countries. Now we have 47 member states to a particular issue of international law, and ALCO work closely with the ILC, International Law Commission, and we provide the output from the countries in the regions. As the issue of the cross-border disputes and international mediation is under our work programs. The Pacific settlement of disputes is one of the agenda of ALCO. And in the past, ALCO Secretariat has urging member states to adopt mediation process in their respective agreements, such as FTA free trade agreements or bilateral investment treaties, and also in investment contract. In order to benefit from the process and promote the cost-effective settlement of investment disputes. And also regarding the Pacific settlement of disputes, which is under our work programs, and ALCO also focus on the establishment of institution dealing with the dispute settlement. As you may know, the mechanism to provide the service for dispute settlements is the center which deal with the dispute settlements. And now ALCO have mainly 6 regional arbitration center since 1973. During the administration, this is the idea that ALCO follow up the work of UNCITRAL in the field of international commercial arbitration, and we conclude to setting up the arbitration, the regional center of arbitration. So until now, ALCO has established 6 regional arbitration center. May I cite as follow? We have the Asian International Arbitration Center in Kuala Lumpur, Malaysia. The Cairo Arbitration Center for International Commercial Arbitration in Arab Republic, Egypt. Regional Center for International Commercial Arbitration in Lagos, Nigeria. And Tehran Regional Center for Commercial Arbitration. Nairobi Center for International Arbitration in Republic of Kenya. And recently, during the last annual session last year, the 59th annual session, the establishment of ALCO Hong Kong Regional Arbitration Center was officially announced during the annual session. So now we have 6 regional center on arbitration. And under the auspice of the ALCO, all regional arbitration function as international institution with the objective of promoting international commercial dispute settlement in Asian African countries and providing for the conducting of international arbitration and mediation. And also the 6 existing regional arbitration center seek to integrate in the ALCO dispute settlement system and perform a variety of tasks, including providing facility for ADR or alternative dispute resolution, services such as mediation for international commercial and investment dispute settlement. And in this regard, let's take an example of the Cairo Center, which offers specialized service to settle trade and investment dispute through arbitration and also mediation. It includes also ADR, such as conciliation, mediation. And apart from this, the center also offers advice to parties to international commercial and investment contract with regard to drafting this contract and promote arbitration and alter ADR, alternative dispute resolution technique in the Afro-Asian regions, to the organization of international conference, seminar, organized training programs or capacity building, because it's very important to provide some knowledge and exchange the idea on the issue of ADR, including the mediation. And also the regional center in KL, Kuala Lumpur, Malaysia, offer facility and assistance to conduct the arbitral proceeding, including the enforcement of award. And also the center issue the mediation rules for the center. And as the mediation process is flexible, now all the regional center on arbitration adopt the rule of mediation for themselves. And also the scope of mediation in every regional center focus on administering domestic and international mediation, including ADR, and providing ad hoc mediation and alter ADR mechanism, providing advice, promotion of mediation and alter ADR mechanism in the regions. Building capacity is very important for mediators, legal scholars from Afro-Asian regions by organizing training programs, workshop on mediation, and coordination with and provision of assistance to alter mediation and ADR institution, particularly those existing within the regions, and also establishing a comprehensive library specializing in mediation and ADR. This is very important, and the task of the regional center established under the auspice of ALGO in each regions of Asia and Africa. And I like also to highlight some recent developments in the legal framework of cross-border disputes and international mediation. For example, two recent developments solicit mention. The first one as Excellency Dr. Aniruddha and Excellency Jawad just raised the issue of the Singapore Convention on Mediation. This is very important, and also many member states of ALGO joined this convention by signing some ratified this convention, and this is the first and very important convention on mediation. And another developments in terms of the legal framework of international mediations is about as Excellency Dr. Aniruddha Rajput raised the issue of ISDS, investor state dispute settlement. This issue is very important today, as you may know that now we have more than 1,200 ISDS cases. For example, if we look at the website of UNTAD, the investment policy hub, the number increased year by year, and the issue of ISDS is now is very disputable in many academic institutions, even in the conference of the UN agencies such as UNTAD, UNCITRAL, even OECD also, and the ongoing discussion on the reform of ISDS, as you may know that the UNCITRAL is mandated by the UN to undertake the reform of the ISDS through the Working Group 3, and the reform of ISDS within UNCITRAL show that there is an appetite from both investor and state for preventing of disputes among them. And several states' submission underline the importance of measures to prevent disputes from arising and redress means to resolve disputes through method of mediation, alternative to court or arbitration. And this is the recent developments of the issue of ASCS, discussing under the auspice of the working group of UNCITRAL. And also the recent reform, as many of you may know that now many countries are in the process of reform of their investment treaties. Now we have more than bilateral investment treaties, more than 2,500 bilateral investment treaty concluded today. And every country need to reform the existing bilateral investment treaties. And the recent reform of treaties signed by many states, either in form of a chapter of investment in the FTA, free trade agreements, or in the bilateral investment treaties, show that mediation conciliation is slowly getting attention and traction in treaty language. This is very important. And under the UNTAD report 2019, identify a number of treaties signed in 2018, which do exactly that. And a review of this provision show that the most advanced text is probably the agreements between EU and Vietnam, which include the integral annex dealing with mediation for the ISDS. So I'm like to highlight these issues, and once again I thank warmly the organizer for this invitation to this very important events, and hope that what I deliver will be fruitful for this discussion. Thank you very much.
Thank you so much, sir, for a valuable insight and further advancing our discussions by highlighting the role of ALCO in international dispute settlements. Now, I would like to make a humble request to Honorable Mr. Justice Ajay Bhenot to address the virtual gathering. Sir has practiced civil, constitutional, tax, service, company law, and criminal side at Allahabad High Court, and also handled matters relating to environmental, industrial disputes, and other allied branches of law. Lordship, the floor is yours.
Excellency Dr. Aniruddha Rajput, Excellency Dr. Camden Pinit Pugdol, Professor V.K. Ahuja, Professor Dr. Ashutosh Mishra, Shri, Jawad. I hope I've got your name correct, sir.
Yes, sir.
I have the good fortune of being preceded by such an eminent and a distinguished panel that I have no hesitation in saying that whatever was needed to be covered as far as international commercial disputes, cross-border disputes are concerned, pretty much gets covered, leaving me with a job which I like quite often while sitting on the bench. When one has very illustrious partners on the bench, that the judge simply writes, "I agree." That covers not only the topic, but also prevents confusion or discordant decisions. But as I have seen this topic, cross-border dispute and international mediation, and from my own experience at the domestic level of mediation, the word cross-border has to be seen in a, if I may say, a larger context, and will have to embrace other aspects of mediation, which may go to the realm of international law, like environmental issues could be mediated. Conflict resolution issues could also be mediated. Refugee problems. And why is this issue of mediation coming up and assuming such importance? We need to look back at the evolution of international law through international instruments and how it has been implemented in various domestic laws and changed the course of human history. After the Second World War, the world was shaken with an unspeakable tragedy, but also guided by the unquenchable optimism of the human race. And we saw the emergence of the UN Charter, which amongst other things said, to save the succeeding generations from the scourge of war. That was the first among the first, subject to correction, international instruments which referenced mediation as a form of dialogue and conflict resolution. The international law and international law instruments, which have often been experienced in our day-to-day working in our national courts as well. I would like to pick up two instruments and the following chain of events. One was the instruments which relate to empowerment of women and child rights jurisprudence. Initially enacted by the United Nations, initially these instruments were ratified by various signatories. Subsequently, all these international instruments started to get reflection in the domestic laws of the country. And finally, all these are now being implemented by various courts of the countries. So it is these values like child rights jurisprudence, empowerment of women, the need for a dialogue, unilateral model, as we have seen, we have an arbitration act and a mediation, arbitration and conciliation act consistent with that. What is happening, this trend, as one would see it, is the emergence of a sovereignty of values. That is, these internationally accepted, or those values on which the Committee of Nations has a consensus, become sovereign in themselves. That no matter what the government, no matter what the ideology of the state, the values will be implemented and become a day-to-day reality in the functioning of the state and the lives of the people. When we speak of mediation, the biggest challenge is to put mediation at that level of a sovereign value. Evolution of the concept of consensual values does not lead to a dilution of sovereignty of the nation state, but it only affirms the sovereignty of values. Why do we need mediation today? I think we would look at the paradox of the technological revolution. We have the benefit of technology. All of us are sitting at our respective places and yet being able to communicate. But yet, with a plethora of devices, we also see a paucity of dialogue. We are chatting more and understanding less. With all these international organizations, we are also seeing that interests often threaten principles. The search for security of one party ends up creating an insecurity for other parties. All this needs a dialogue, a framework, and a medium of dialogue. Mediation offers that method. One of the methods in which a dialogue of humanity can happen on all issues, including commercial disputes. Mediation is less adversarial, as my esteemed preceding speakers are saying. It is a flexible approach. And the most important thing is the parties retain their agency. That is a critical aspect. But when we come to international mediation on international issues, be it trade, it can also be an environmental litigation, say water, environment does not recognize our man-made borders. If we have, say, an environmental issue which is coming up, it can be resolved through international mediation. So, but the complexities of international mediation, of course, have also been partly captured, or rather very deftly captured by the preceding speakers. In fact, there is also an article by Dr. Ahuja who talks about cultural gaps or cultural issues, be it cultural issues or be it a historical baggage. these are all aspects which come into the way of countries accepting mediation, societies accepting mediation as a viable and a legitimate method of dispute resolution. You have issues of mediator bias. Now, if we see some of the international disputes which were resolved through mediation, Camp David comes to mind, where Israel and Egypt signed a peace accord. You had the Norwegian mediators intervening in the Israel-Palestine issue. But on the other side, we also find at times you have an arms supplier to a conflict who's coming in as a mediator. I don't know what will happen in that fact situation, but the credibility of mediation as a process will definitely take a beating. So what we need today is to create acceptability for mediation in various facets of our life, which are all entangled. We live as a global village today. We have to entrench the indispensability of mediation. There is no substitute for dialogue, war, and litigation. War between nations and litigations between investors and states are often seen as not as viable options or alternatives. And that is where mediation comes in. Communication. Now, invariably, mediation helps to reignite the dialogue between parties. You need good communicators. I have reverence for all seers of the world, but I would just, after paying my homage to all, I would just remember Gautam Buddha. He did not have the benefit of WhatsApp, and yet the whole world is bowing before his eternal wisdom. Communicators. A mediator has to be a communicator. We have to invest this process with legitimacy and organization. In my experience as a judge, what I found was that international instruments become a very important source of legitimacy. Once international instruments, countries become signatories to international instruments, they enact laws. And once those laws are enacted in domestic jurisdictions, they are implemented and executed through the state agencies and the courts. That is a formidable act of creating legitimacy. And once that legitimacy is created, a whole structure, a detailed process, and as the preceding speakers was discussing, enforcement of the agreements, a plan has to be laid out in that international instrument. A pool of mediators and their training, as His Excellency Cameline was saying, the training of the mediators, it becomes very critical, because that is what builds the capacity of the society, the state, and the international community. Training of the mediators to create a pool of mediators, because as I said, bias, interest, now you have that. We are all aware, I don't want to repeat that, but that situation where one party is supplying arms to a belligerent in a conflict and also acting as a mediator. So we need to go beyond that. The international instruments reflect the ideals. The structure of the regime reflects the will of the international community. I began by drawing from the most modern charter comprising values and endeavors of the human race in the modern world. I would like to conclude by invoking the most ancient scripture, manifesting the ideals and the stirrings of humankind, when our sages of yore said, Loka samasta sukhinu bhavantu. Let all of humanity experience happiness and contentment, because sukhinu, sukh does not have an exact translation in happiness. So it is contentment and happiness. So with this, mediation would probably be showing the way to achieve that age-old striving of the human race. With this, I would like to conclude and thank the organizers and my preceding speakers, and ladies and gentlemen, for a very patient hearing.
Thank you, Your Lordship, for sharing your valuable insights. Thank you for highlighting the need of mediation in this ever-changing world and the various facets of our life. I would like to respectfully borrow a line from your speech. A mediator needs to be a communicator. Now I would like to request Professor Dr. V.K. Ahuja to share the concluding remarks and propose a vote of thanks.
Thank you,
Sir, the
Dhananjay.
stage is yours.
Thank you, Dhananjay. It was a wonderful session, and all the speakers, they have given various aspects of mediation. I was just listening to them very carefully, and there were some very good remarks coming from them. Starting with Mr. Jawad, he had rightly pointed out that commercial disputes have taken a new dimension now, and then he quoted a paper where, in the paper, some reasons were cited like the cost delay, technicality, lack of qualification of national judges. Then he also pointed out the problems in arbitration also. Now that was something, I was examining a thesis on arbitration, and that thesis was written by a very senior official of PSU, Maharatna company. And, that PSU used to be going for arbitration. And he pointed out how this arbitration has become very expensive, very time consuming, because, the arbitral awards were being given, they were being challenged. And once the judgment comes, review petition was also being filed. So ultimately, it was taking a lot of time. And if you see the arbitration fee, it was going very, very high nowadays. So therefore, he focused on conciliation because mediation bill was not introduced till then. And of course, arbitration, which used to be considered as one of the preferred choice, is now losing its charm. Mr. Jawad has also pointed out the ODR resolution, which of course is extremely important. And I would definitely like to listen to him exclusively on ODR resolution, which of course is going to stay. Because in ODR, you need not travel to the seat of mediation. And then about satisfaction result, he talked about 87% of the companies had shown satisfaction towards mediation. And this is something which is very encouraging and very promising. So one can, very well argue that mediation is going to have a good future. Coming to His Excellency, Dr. Aniruddha Rajput, he talked about the mediation bill. He talked about his comments, which were sent to the Honorable Law Minister, where he said that the text is nice, but then the culture should also be nice. And then he talked about mediation in the investment agreement. And he raised a question which is very pertinent. Do we have the environment conducive for mediation? Dr. Rajput has pointed out one issue which in the morning also I have also raised when we were talking about mediation in IPR disputes, and that was about credibility of mediator. Now, if you see the Commercial Disputes Act 2015, which was amended in 2018, and thereafter in 2018, the rules were also framed. If you look at section 12 of those rules, it talks about ethics for mediators. So where, it's a long provision where some ethics have been prescribed for mediator. Now, this is something which is extremely important because we are venturing into a new, mode of resolving disputes. And we should not forget that if the credibility of this system has not been established, then it may also fail, like any other system. If the mediators are doubted for their integrity, then obviously this will be a big blow to the institution of mediation itself. So that is something where we have to look more into the credibility of the mediator. And of course, we have to train mediators, as to what is to be done, what is not to be done, and how he has proved himself to be impartial to both the parties. Dr. Aniruddha Rajput has also shown a flip side of mediation in the investment matters with respect to confidentiality. Now, that is something, which of course is completely new to me. And of course, if it is based on some experiences, then it is really a matter of concern and one need to think about it, particularly in the investment matters. Moving on to His Excellency Kamalin, the presentation was really wonderful, where His Excellency has pointed out the role played by ALCO in the Pacific settlement of disputes. He talked about the 6 regional centers of arbitration, which are doing very well. There is one point which he has very rightly pointed out, and that was the building capacity of mediators of the people, as mediators in Asian and African countries. And for that particular purpose, ALCO is organizing a lot of programs on mediation. Now, that is something which is extremely important and which is very much required. And Excellency has also pointed out about the members of the ALCO who had joined Singapore Convention. And of course, many more will be joining soon. So finally, Lordship Mr. Justice Ajay Behnot had talked about mediation in international law. In fact, to be very honest, I have never come across a judge who spoke so well on the matter of public international law. Normally, I have seen judges, they are very good in national law, but I could see Justice Ajay Behnot, who spoke very well on various aspects of public international law and how the mediation can help. Particularly, he talked about environmental cases. He talked about refugee matters also, where mediation can play a role. And then one example which he has given, that suppose if a country is mediating and at the same time, it is also providing, arms and ammunition to one of the parties. Now, obviously, we are denting the very credibility of that particular system, which should not be there. And Lordship, you have very well given the example of Buddha, where you said that, well, there was no WhatsApp at that point of time, but he happened to be one of the best communicators, and the entire world was, benefited by his external wisdom. With these words, on behalf of Faculty of Law, University of Delhi, Delhi School of Public Policy and Governance, which is an institution of Eminence, and MCPC, Mediation and Conciliation Project Committee of the Supreme Court of India, I thank Honorable Lordship Mr. Justice Ajay Behnot for chairing the session. I also thank His Excellency Dr. Kamalin Pinit Puwadol for co-chairing the session. I'm also thankful to His Excellency Professor Kennedy Gaston, the former Secretary General of ALCO, and who is presently Ambassador of Tanzania to United Nations, for connecting me to His Excellency Dr. Kamalin. Professor Kennedy could not join us as he is traveling, and there is issue of the time zone also because he is presently in the United Nations. I'm also thankful to my friend and guest of honor, His Excellency Dr. Aniruddha Rajput, for being with us for the conference. And His Excellency has always supported all, his help to our academic ventures whenever we approached him. My thanks are also due to our special guest, Shri A.G. Jawad, who has always been kind to us and who had always graced the occasions whenever we have invited him. Thank you, sir, for being with us. I'm also thankful to the Dean Faculty of Law, Professor Usha Tandon, and my colleague, my brother, Dr. Ashutosh Mishra, and entire of his team, which are working day and night to make this conference success. Finally, I'm also thankful to MCPC Supreme Court and its officials for giving us an opportunity to collaborate with them and to organize this particular conference. Thank you very much. Namaskar.
Thank you, sir, for your kind words. The insights shared by the panelists have truly been thought-provoking and informative. I thank all of the people who have made this session a huge success. With this, the session comes to an end, and I request all the participants to fill the feedback form available in the chat box. Kindly note that filling the feedback form is mandatory requirement for certificates. Thank you, and I wish everyone a great day ahead.